All right, folks, we are getting ready to get started on our 10 o'clock criminal docket. I'm going to ask everybody that is not involved in whatever hearing we happen to be doing at the time to be sure you keep your microphone muted so that we don't hear a bunch of things that nobody wants us to hear and we don't want to hear. And then we will, when it's your turn, you can pop that mute button and we'll hear from you. All right. Does the Commonwealth have anything that it wants to go ahead and do, or, we've obviously got a kind of a mixed bag here I've got Barron County Jail on. We've got several guys here, folks here that are out of custody, and looks like I got Mr. Davis on here. He's probably doing a conflict case, but I don't know which one it is.
It's Jason Booth, Your Honor.
Oh yeah, I don't have them on. He's at Montgomery County Detention. Is that right?
Yes, sir. Yes.
Yeah, they hadn't joined us yet. All right. Let's. Oh.
He's been moved to Rotor.
Oh, okay.
And he has to quarantine for 15 days.
Oh, shoot.
So they didn't give me or longer, she said.
Oh.
So they didn't give me a date of when.
Mr. Davis, can you jump back on here?
Yes, sir.
Apparently, since last week, he's been transferred to Rotor, and they're quarantining him for 15 days before they'll let him get on it. They just called.
Okay.
They didn't give us a specific date he would be done, but they said that he had to quarantine for 15 days. What day did he get there?
4:15.
Okay, yeah. So he's gonna have to be, I mean, I bet you by May the 3rd. No, that'd be cutting it real close.
Your Honor, I'm sorry. Do you know, did they transfer him just because he had to be quarantined?
I'm telling you all I know. I think maybe
Okay.
just because he's a state inmate, that might be why he got moved.
Okay.
Because he was staying there as, under the Class D exchange program, but I believe that they've put him in a state facility now.
Your Honor, could we possibly go forward on that case right now? Then he's not going to be here, and could we set it for another pretrial conference on 5/17 at 10 a.m.?
Yes, I have one question, and this is why my question is. They told you that he had been moved on 4/15, but we Zoomed with him last Monday in Montgomery County Jail, which was 4/19. So he did not get moved on 4/15. I don't know. I don't know, but they called and said he would be quarantined for 15 days from 4/15, but he didn't get moved on 4/15 because we were with him on 4/19. He was with us on 4/19.
Yes, sir. I'll look into it, sir.
Yeah, out of the Montgomery County. So when would you like me to reschedule this?
5/17, please, Your Honor, at 10 a.m.
All right, that's fine. The date is fine with me. I will give you one other thing, which is in the past, they have told us that they want us to do 1 o'clock at Rotor.
Yes, sir. We can schedule it for 1 o'clock. I've just got to be in Hart County at 1 o'clock as well.
Okay.
But that'll be fine.
Yeah, I just didn't want to tell you. I mean, my experience with that facility is that every time we set something at 10, they call and say, "Can you move it to 1?" So I was trying to get out ahead of it.
Yes, sir. I'll mark it on my calendar for 1 p.m.
All right. So 5/17 at 1.
Please, sir.
Gotcha. Is that the only thing you're here for?
I believe so, sir. May I be excused?
All right. Yes, sir. See you later.
Thank you, Your Honor. Thank you.
All right. Let us look and see what. You all want to just go ahead? Why don't we try to go ahead and take up the folks that we have in the jail, or at least start with that, and then if any of the attorneys.
Judge, Xanda emailed me this morning about Miles Bush. She said that he is working at this time and I guess is taking a break from work in order
Okay.
to attend here. So
All
she
right.
has to call this, you know.
All right, Mr. Bush, can you hear me?
Yes, sir. How you doing?
All right, very good. This is on for a pretrial conference in 20 CR 318. Is there anything that we have to discuss?
Xanda, can you provide me proof of employment for Mr. Bush?
I believe I can do that. I can do that pretty quickly, I imagine. So,
If you could provide me proof of employment, I will give him credit, obviously, for the days he's already served towards that alternative sentence. And then do you know how many days he has that would credit towards that proposed alternative sentence?
I'm not real sure. I know we did a bond
20
revocation.
days.
We got that sanction. Was it 20? I think it's 20 days. Yeah.
Yes, ma'am.
I just
So
wasn't
it'd be-
sure if he was served any days when he was initially picked up.
Provide me proof of that employment status, and then I'll double check on the days. I'll probably agree to the home incarceration for the remainder, but it might be, you know, like double time as far as what's remaining
Okay.
Thank
for
you,
home
sir.
incarceration.
Ms. Myers, it looks like he was arrested and ROR'd on the same day initially. So on November 7th. And so other than the sanction, I'm looking at the file. I don't see any other credit.
Thank you, Judge. I appreciate that.
Because this was a direct indictment, so there wasn't any district court.
So, you know, with that information, essentially I would agree to 45 days on home incarceration
Okay.
with no credit. I mean, obviously towards that, I mean.
Okay. Miles, I'll text you. Okay. And try to get a letter. We'll talk. Can we set it over a week, Your Honor?
Yes, that's fine.
Okay.
That'll be May 3rd.
Thank you.
Mr. Bush,
Yes, sir.
if you all have it sounds like you might have an agreement here. So if you do, all other things being equal, it would be my preference for him to come in and do that in person, because I can do an in-person one next Monday if that's adequate. But I would defer to you if you had some issue that kept that from happening.
No, sir. My boss is pretty lenient with everything that's going on. I told him what's going on, and I worked
Okay.
this morning and come back home just to do the video, and I'm going back as soon as I get done. That way I don't miss the full day.
All right. Yeah, very good. I would prefer to do that. And we don't have to do it at 10 if you would rather do it in the afternoon, but either way, I'd like to do it in person. Okay.
Yes, sir. What time would be good for you?
Oh, I'll be here all day. So I have it at 10 right now.
Okay, that's fine.
All right. Good enough. I'll
Thank
see you
sir.
next Monday at 10. Okay.
All right. Thank you, Your Honor.
All right. You're free to go.
All right. Thank you.
You bet. Let's see. I don't know. Mr. Gardner, just jump in if you got me. I see Mr. Tucker on here, and I don't know, he might be in a,
I filed a motion on Mr. Tucker, Judge.
did you?
I did.
I see Mr. Basil, so. All right. So, yeah, so the Commonwealth has a motion to revoke bond on the basis of what looks like a new charge in March, and then some other information that we've got here from the monitoring folks. When do you want to set that, Mr. Richardson?
Whatever the next revocation date's fine, Judge.
All right, that would be taking tomorrow out of the equation. That would be May 11th.
That's fine.
What time, Your Honor?
1:30 in the PM.
I have a hearing, actually 2 hearings in Allen Circuit Court at that time.
We could do, Mike, I wouldn't have a problem doing it on Monday. You know, that's the day that the DPA, most of them are going to be gone. So, you know, we'll have less going on Monday, on the 10th than we normally do at either
That'll
10
work.
or 1.
What time do you want to do it?
Whatever works for I mean, you'll be available and I'll be available. So let's see what Mr. Basil has to say.
The only hearing I have that day is Warren Circuit Court at 10:30.
All right. Will you be doing that live or remote?
That's a good question. I don't know.
Yeah.
I assume it will be remote still. So we could do it anytime that afternoon, though.
Yeah, let's just put it on. We'll put it on the 1 o'clock docket then. And because, you know, especially the nature of it being a motion to revoke bond, we will do that in person. That is May 10th at 1 o'clock. All right, I'll see you all then.
Thank you, Your Honor.
Thank you. All right, let's see. I'm just going to run down through here and start calling them since nobody's jumping up. Michael David Bixler. He's in the Berrien County Detention Center. Mr. Bixler, how are you today?
All right, yourself?
I'm doing fine. Are you able to hear me okay?
Yes, sir.
Okay. What I believe we're on here for today is a final sentencing. Is that correct? In 20 CR 349 and in 20 CR 314?
Yes, sir.
Have you had the opportunity to look at your pre-sentence investigation report that was prepared and filed in this case?
I have.
All right. Is there any reason that you or your attorney might be aware of that we should not proceed with sentencing in this case today?
No, sir.
All right. Ms. Myers, is this one yours? I'm trying to remember.
It is, Your Honor. There was a couple corrections to the PSI that I wanted to note for the court.
Yes, ma'am.
On the portion about his current medical conditions, he actually has an abnormal EKG, and he is on 4 different prescriptions at this time. And Mr. Bixler can tell the court what prescriptions those are if you need that, but he does have some current medical conditions. But otherwise, I believe everything was correct in the PSI.
All right. Mr. Bixler, you sure don't have to say, if you don't want to, what kind of prescriptions that you are on, but that if you want to, just so that I can make or so that our probation, we have a probation officer on here, and so that he can make a record of that, that's fine.
Oh, they were various blood pressure medications.
Oh, okay. All right. Fair enough. All right. So would anybody like to be heard prior to imposition of sentence? All right. In this case, the Mr. Bixler entered a plea of guilty in 2 separate cases, 20 CR 314 and 349. The total, let me back up. The 314 case, which I have here, is the plea was based upon an offer from the Commonwealth of a 14-year sentence. The 349 was based upon also an offer from the Commonwealth of the same sentence, and the two sentences the Commonwealth was taking the position should run concurrently with one another. The Commonwealth took the position that based upon the nature of the charges and other factors, the Commonwealth was opposing probation. Ms. Myers, is that your understanding of what the Commonwealth's position is on the sentencing?
Yes, Your Honor.
All right. And Mr. Bixler, I do want to say that, you know, I appreciate your cooperation up to now, up to this point with previous orders of the court. And I appreciate the fact that you have accepted responsibility. I am going to, based upon your two offers, going to sentence you in accordance with those offers. I'm going to waive any costs or fines on your part. There was in the plea offer a discussion of restitution in at least one of the cases. It's not a huge amount of restitution, $145, I think. I do believe that it is unreasonable to expect you to pay that while you were in custody. So I will only order that that be paid within 6 months of your eventual release from custody, so that you have a little bit of time once you get out to get a job lined up or whatever it is and get that 140 some odd dollars paid. Okay.
All right.
All right. Do you have any questions?
No, sir.
All right. Then I'm going to enter a judgment imposing that sentence in each of these two cases. And Mr. Bixler, you will remain in custody of the Barron County Detention Center unless and until they, the Department of Corrections places you elsewhere. Okay.
All right.
All right. Good luck, sir. Thank you.
Judge,
Yes.
I see Chris Davenport on here. He represents Cody Stinnett. It's set for pretrial this morning. We
Okay.
haven't had any discussion, so I would imagine either we're going to set it for a trial or for another pretrial conference,
Okay.
or both.
All right. Mr. Davenport, you ready? I'm not able to hear you, but you are not on mute. Now you're just not here at all. Well, bless you.
We can recall it when he
Yeah, let's come back to it.
reappears.
Yeah, let's come back to it. He might have to jump back in. There he is. All right, here we go. All right, Mr. Davenport. He gonna try again. In the meantime, let's call Trevor Burton. He is in the detention center.
Oh, Your Honor.
All right. Hello, Mr. Burton. This case is on for a,
I think it's supposed to be for an arraignment, Judge.
well, that's a good question because I think that, yeah, I think that this has been pending for a minute and we hadn't ever been able to get the arraignment taken care of. So here we are. Mr. Burton, you are present today, having been indicted by the grand jury of Barron County on charges of possession of a controlled substance, first degree, first offense, driving on a suspended or revoked operator's license and no insurance. Do you have an attorney?
Yes, sir.
Okay. Can you tell me who that is?
Gary Berry or something like that, public defender. Old guy. I don't really remember his name. Greg Berry.
Oh, okay. Is that you, old Mr. Berry?
It is.
Have you spoken? We haven't had anything really happen in circuit court yet.
Right.
But-
No, I've not talked with him.
Gotcha. So I will make it official then and appoint. I know you all your office had been appointed back when this was a
Right.
case in district court. So I will make it official up here in circuit court and appoint you as well. Do you wish to have a formal arraignment on these charges?
No, we would waive formal arraignment and enter not guilty plea on all charges.
All right. Mr. Burton, I am going to appoint counsel for you, and then you all can discuss what's happening in your case. Mr. Berry, the part of the issue here is that the Commonwealth has a motion to revoke bond. I think Mr. Burton has a pending case in Metcalfe County,
He
and so
does.
he's probably on the docket tomorrow for that.
It is.
And I don't know if there's a similar motion in that case or not, but just to keep things from getting all tied up, we probably need to just leave that on the docket tomorrow and deal with that. But as far as this case is concerned, the big kicker, I think, was that he was on a bond out of district court, and there was some allegation that there was non-compliance with the conditions of that bond, which is how come there was a warrant.
Judge, I had filed the motion to revoke his bond in Metcalfe. Obviously, he was, we couldn't find him. So tomorrow he's got a pretrial, but we'll be setting a hearing date if we can't come to an agreement.
Okay. So, Mr. Berry, are you going to be able to join us tomorrow in the morning?
Yes.
All right. Why don't we do this? Why don't I go ahead then and just enter a not guilty plea for Mr. Burton in this case? I'll set him for a pretrial conference. But if you all are able to come to any sort of agreement or accommodation on both cases, you all can tell me. If not, let me put him on for a pretrial conference in about 45 days in this case, and we'll go from there. He's, because he's got, what I'm trying not to do is get things confused between the two cases. So, in this case, if we have to have a hearing on the bond revocation, we'll do it in both cases at the same time, the Metcalfe and the Barron.
Okay.
But I'm not going to set that hearing right now just because you all may come up with something tomorrow that obviates that, and then it'd be more confusing to unset it than to set it. So,
Judge, I may have missed it. What's he charged with over here in Barron County?
it's possession first degree, suspended license, no insurance.
Hey, Greg, I don't know if you remember, we had talked about his case in Metcalfe, but he never showed up. That's why and we were waiting for this case to come up here. So
Okay.
I'll get with you today. I
Okay.
think we can probably work it out.
All right.
All right. So in the meantime, just as, as a placeholder, if nothing else, I'm going to put this down for a pretrial conference on June 21st. But then, because the Metcalfe case, you all have already been talking about it. And if you get something worked out on it, we can take care of both cases simultaneously.
Yeah.
Okay.
Okay.
All right. So Mr. Burton, we'll be seeing you tomorrow, okay? Because you're Metcalfe.
Yes, sir.
All right. Thank you. All right. Mr. Davenport, you've had to call an audible.
Judge, I apologize. You think after a year of this that I would not be having any technical difficulties, but they say there's a first time for everything. So there you go.
I would not think that, because technical difficulties are something that we always get to enjoy, no matter how much experience we've got.
Well, I appreciate your patience as well as Ms. Gardner's patience.
Yeah, she's the one you got to worry about.
I understand. I did
Yeah.
hear she gave a correct recitation of where we are. I will leave it to the court's discretion whether to set a pretrial and a trial date or just a pretrial. But our discussions have been pretty much nailed today. We've discussed a few things regarding the discovery, but nothing too substantive.
Well, let me tell you and this is kind of in a vacuum since I don't know a whole lot about what's happening in this particular case, but these trial dates are kind of few and far between. I sure don't mind setting one, but if I did, I would not want to, I would probably set it while we've got some other things going on, just as a way to get us something to shoot for. But it's awful tough to know when we're going to be able to try something. We're fixing to give it a shot here in a few weeks and see how it works. But I don't know how that's going to go or even what the rules are going to be as we move on down the road. But we think we're going to be able to give it a try.
I've not been in front of a jury for over a year, obviously. I'll tell you that bench trials and family courts are starting to get pretty heavy. So maybe that's the trial run.
Yeah, I mean,
Your
go ahead.
I'm sorry to interrupt. I don't know if we want to just go ahead and set a trial date in 2022. I mean, right now, I don't see this case resolving. But I also think the nature of the case, I don't think it's one that would require precedent like a child abuse case or someone who's incarcerated. I don't know how Mr. Davenport feels about that.
I don't disagree.
Yeah. Well, let me tell you all, if and I just know this because I just went through this on the civil docket about an hour ago with a case. Way back when all this pandemic stuff was hot and heavy, we had a bunch of different civil cases that we didn't want to set and then have to move. So we just agreed to put them all the way out into 2022. So starting in January, I've got, those things are just stacked up like cordwood all the way to May. I've got 2 or 3 medical malpractice cases and 2 or 3, big time cases where all the witnesses, several of the witnesses are coming from out of state and all that. And I'm not going to be able to move those around. I kind of set them way out there so that I could tell all of those people that were subpoenaing out of state doctors and all that I wouldn't move it on them. So if we take that tack, that's fine. But I mean, it's going to end up being, May before I have any time to do it, unless you all wanted me to set it behind something else and then run the risk of not getting it done.
I'd probably rather not set it behind something, Your Honor.
Yeah. Well, most of those have been set for well over a year, so I mean, if they were going to work out, I would think they would have by now, but there's always, I guess.
Although never underestimate the value of a pending trial date to forge compromise.
No, that is very true. Unfortunately, one of them is a 2013 case and one of them is a 2015 case that they've tried to mediate multiple. Well, they're all cases that we got into it and then somebody had to have surgery and you had to wait like a year to see how the surgery went. One of them was a child that had to have a kidney transplant, because of what happened. And, we've had to wait like 4 years to see how she's had 2 kidney surgeries and, so, I mean, they're going to be ready to go when the time comes. They're going to have to. But now I just set a trial today on May 4th, 5th, and 6th. So the week after that, I could pretty readily do pretty easily, which would be May the 10th of that year will be our Metcalf day. So I can't really set a trial then, but I'd have the 11th, 12th, and 13th if you all thought 2 or 3 days.
That would be plenty of time, Your Honor.
Yeah. Is that, Ms. Gardner, can you live with that?
Yes.
All right. So we'll pencil that in right here at 20 CR 164. And let's do a pretrial that's going to get us on what I'd like to do is maybe do that in January, so that, we're not waiting too long and we're not pushing it up too close in case there are some issues that have to be discussed. That'd give us enough time to do it. So let's go for January how about the 10th?
That works, Your Honor.
Will that be at 1 o'clock, Judge? And then we're doing it at 10.
Yeah, that'll be at 1 o'clock. I mean, unless you all agree to do it some other time.
Okay.
And I believe that's got us taken care of for now. All right, any questions?
No,
No, Your Honor.
All right, thank you. We'll get an order out to everybody, okay?
Yes, sir.
Thank you.
Have a good week.
You too. All right. Jackson Dockery.
Judge, that's my case, and he's set for a sentencing this morning.
Yes, sir.
I could not get, I tried this weekend to print the PSIs. I could not get them to print. I finally got, Denise ran down, printed them this morning. I took it up there, but I don't know if Jackson's had a chance to look over it yet.
Judge, I was going to ask for the sentencing to be put off. Part of the deal was there was a global offer that was also made out of Ohio County to resolve this case. And whatever reason, at their last court date, that has not been resolved. I was going to ask to push it out till after, well, I don't think we have to do it after his next, let's see, I think May the 18th was his next appearance in Ohio County. So I was going to ask to put it off after that to make sure he enters his guilty plea, because that's part of the deal here.
Okay. What, Mr. Berry, I'm sure that you're not handling that case, but do you know anything about the status of that?
No, it seems like there's some back and forth about trying to get him into rehab. First of all, no, I'm not handling the case, but I did get an email. It's been a little while ago, 2 or 3 weeks ago, and I'm trying to remember if this is the right case I'm saying this on, but I believe that they were trying to work out a rehab program for him in Ohio County or on the Ohio County case. Does that sound right, Jackson?
Yeah.
Okay.
I mean,
Maybe there's been a glitch in that. I don't know, but
Well-
that's the last I've heard of.
Okay.
I mean, that's kind of, I don't know, that's completely opposite of what the prosecutor told me. And Greg, I mean, Greg, did that come from Dockery or did that come from Ohio County? I mean,
No, it didn't come from Jackson. It came from, I don't remember. I hate to say who it came from, but
yeah,
it was.
I understand, but
That's what I understood, that they were trying to work out a deal for rehab.
let's see here.
Well, I do know that, Mr. Richardson is correct in terms of that. We discussed that at the time of the plea. And then of course it's also memorialized in the plea offer that the plea was, I think it would be premature to sentence because the terms of the plea were contingent on there also being a guilty plea in Ohio County. And I think until that happens, I don't know how to handle move forward on the sentencing in this case. So I don't have a problem if you all think that can be done at or before that next hearing, which is, I believe you all said May 18th. I could move this to May 24th and we could, see how it's shaping up.
Let's do that, Judge, and I'll call the prosecutor and see what's going on, see if what the issue is, if there's an issue.
All right, so May 24th at 10 a.m. All right, thank you all.
Is that it?
Yes, sir. Thank you.
All right.
Which I guess we can do. Jeffrey Dugard.
Your Honor, that's my case. I have a pending motion to revoke probation.
Yes, ma'am.
I talked with Officer Bray this morning. I emailed Greg and offered to resolve this of a 30-day sanction if Mr. Dugard would be willing to take that.
Yeah, I haven't been able to, hadn't had a chance to convey that to Jeffrey yet. Would you be interested in something like that, Jeffrey? You'd have to serve 30 days and then be let back out.
Yeah, that'd be okay. I had that at COVID-19. It's the reason why I couldn't come into the office. I told him once. I tested positive for it. And that's the reason why I couldn't come into the office. They told me to leave.
Okay.
And why I didn't show up. I still
Well,
got
the proof of the hearing would be that Mr. Dugard didn't show up for several months.
I still got my paperwork on it showing I was negative or
All right.
positive.
Well, we're not going to have the hearing. The issue is whether or not you would like to accept this offer from the Commonwealth to just serve 30 days and then to go back on probation and try to, attack it in that angle. If you don't want to do that, that's fine. I'm not going to make you. But if you do want to do it, we can just wrap it up right now.
Yeah, I can go ahead and do what Mr. Berry said, 30 days or something.
All right. Do you know when you got arrested? Because there's no nothing in the file showing it. I mean, we can find out. It isn't like I can't find out.
I think I've been in here for 2 days.
It was the 23rd, Judge. He got arrested.
It was the 23rd.
All right. Gotcha. All right, Mr. Dugard. So, who's your officer?
Mr. Berry.
No. Who's your probation officer?
Wes Bray.
All right.
Yeah, I'm sorry.
It's
Well,
me, Your Honor.
As luck would have it, Officer Bray is on this phone call right here, or this Zoom call. Officer Bray, Mr. Dugard has agreed in lieu of revocation to do a sanction of 30 days. We'll start that on the August or April 23rd because that was his arrest date. And that ought to be putting him out, somewhere in the ballpark of May the 21st or thereabouts. I don't know whether it's going to be a Friday or a Saturday because I hadn't counted up all the days. But I guess your instruction to him would be to report on the first business day.
Absolutely, Your Honor.
All right. Mr. Dugard, do you have a number that you can get in touch, or do you want him to come to the office, Officer Bray?
Just go ahead and come to the office. I won't look at him.
All right. So we're going to do an order that memorializes this, and it will have the exact date that you're getting out on it. It'll have the instructions on that. So if that happens to be a Saturday or a Sunday, then, you don't have to report till Monday. If it happens to be a weekday, you need to report the day you get out. Okay.
All right. Gotcha.
All right. And you're going to have to give me your address because that's part of that is what's, been the issue. Okay.
Yeah. Okay.
All right. All right, Mr. Dugard. Thank you.
Yeah.
April Glass. Okay, this is a case where we're on for arraignment. Ms. Glass, do you have an attorney?
Not for this case, because it kind of coincides with my other custody case with Matt Robertson in Hart County.
Okay. Okay.
But as far as for a criminal lawyer for this, I don't have one quite yet, but my family's working on getting me one at the moment.
All right. Well, for our purposes here today, what I think I'll need to do is appoint an attorney to represent you. And then, if you end up hiring an attorney that is not the one that I appoint for you, then you can discuss that or that attorney can discuss that with the public defender and get that straightened out. Okay. In the meantime, Mr. Berry, I'll need to make an appointment of someone in your office for the purposes of moving forward in this case.
That's fine. I'll do the arraignment, Judge.
All right, Ms. Glass, this is 21 CR 102. It is an indictment from the grand jury charging you with the offense of criminal abuse in the first degree, child 12 or under. That is the only charge, I believe, in the indictment.
Judge, we would enter a not guilty plea and waive formal arraignment and request pretrial date.
All right, Mr. Berry, that's what I'll do is put her down here for a not guilty plea. We'll set it for a pretrial. Ms. Gardner, will you be doing this one?
Yes, sir.
I guess I'm just trying to, are there any other court dates that you're aware of that we should be working around? You know, when I set this pretrial, or can I just go ahead and set it? It will be towards the end of June.
I think that would be fine. I will be out the last Monday in June.
All right. All right. Can I do June 21st then for?
Sure.
And Mr. Berry, I know that the next question is going to be a bond related question. I do not have any information about any sort of risk factors or anything, which I can look all that up. I just haven't done it, haven't had the chance to do it. But I'm going to assume that you're moving to modify her bond, and I'll just have to take that under advisement. Now I'll let Ms. Gardner say what she wants to say. The bond right now is $7,500 cash. That was set just based upon the nature of the charge, and which is a Class C felony. And, you know, but I'm sure there are other factors that I need to take into account.
Okay.
Your Honor, I do think that's appropriately set, but I would ask if we were to modify it due to the serious nature of the charges, the fact that it involves a young child, that at least some security needs to be put up. I would acknowledge she does not have a criminal history, at least in Kentucky that I can see. I haven't had an opportunity to view anything outside of the state if that exists, but just because of the serious nature of the charges, I do think that something does need to be put up to secure her appearance in this case.
Do you happen to know, without getting into any details, if there is any sort of family court case or? I
think that's what she was referring to, Judge, in Hart County. Because I think, and I haven't looked too deep into this because I just got this case today, but I believe she resides in Hart County. And that's why any family court matters would take place up there. There's a Hart County social worker involved in this case, but it happened in Barron County.
I got you. All right. So, Mr. Berry, like I said, I'm just kind of imputing to you all a motion to modify her bond. I'll look at the information that pretrial has available, and then I will, you know, if I'm going to make any changes in that, I will do so by written order. Okay.
Okay, Judge.
All right. In the meantime, let's reiterate that we have a pretrial conference in this case set for June 21st at 1:00 p.m. I anticipate that we will be able to conduct that particular pretrial conference in person if Ms. Glass is not in custody. If she is in custody, it will be on video, like this format. Okay?
Okay, Judge.
So what about a bond? I have family members waiting on me to figure out whether I can like get a lower bond or a.
Well, I'm gonna listen, that's what I've just been saying. I'm gonna consider the factors, and I will see whether or not your bond is gonna change. I can't tell you right now. Okay?
Okay, I was just wondering because they was been waiting on me to figure out something, so.
I understand. All right, thank you. Marvin Harris.
That's my case, Judge. I think we'll need a hearing date.
Gardner, is this a motion? Yeah, is this a probation revocation motion?
Yes, and there was, I looked at it this morning. I can't remember if there's already a pending motion, but I believe there's a new felony arrest too. So if there's already pending motion, there'll be a supplement to that. If it's not already pending, then a motion will be filed.
Yeah, your motion that you're referring to was filed back in July of 2020, so there may be
Okay.
a need to update that. Mr. Harris, am I going to need to appoint a lawyer for you?
Yes, sir.
All right. Our biggest issue that I foresee here, and Mr. Harris had counsel from the DPA back when the case was originally before us, so I will reappoint. But
Right, I think I represented Mr. Harris, Judge.
I'm going to guess that there is also a motion that if it hasn't been filed, it will be filed. He was on probation out of Metcalfe County too, so there may already be a motion over there, or if there isn't yet, there probably will be. Where I'm going with it is our next revocation date would be May the 11th, and I'm not sure that anybody from the DPA will be available on May the 11th, unless there's something that I don't know. I can't set it on that date. I guess we could try to do it on the following Monday, maybe.
I won't be in court on the following Monday, Judge. If that's the 17th.
Yeah.
Could we do it on the Friday following the 11th?
Sure. Well, I say sure. The spirit is willing, but let me see what the flesh says. What day?
What exactly is this revocation over?
Do what?
What exactly is this revocation over, or what today?
I'm going to guess it's probably because your probation officer reported that you absconded and they haven't seen you for going on probably 9 months. And then apparently you got a new felony arrest.
That would be the 14th, Judge.
Yeah, I mean, I think I could do the morning of the 14th.
That works.
Yeah, 9
And
o'clock.
I
We'll do
didn't
the
check.
Metcalfe. Go
I
ahead.
will be Metcalf too.
Yeah, we'll do the Metcalfe too.
I didn't get a new felony arrest. Because you remember I had that pending, where I gave the Camels Hill on me on my false identification. When I went, they gave me a year. I had to serve a year.
Let me double check. I thought that I saw that.
Well, I don't know anything about that. I mean, that's.
And what I'm here today, sir.
There's a Barron 21F 248. You were charged on April 25th, possession of synthetic drugs, second offense.
Yes.
So that's a new felony arrest.
Oh, synthetic, okay.
Sounds like it.
All right.
All right. So we'll see you on May the 14th at 9 a.m.
What about bond, sir?
No, sir.
All right.
Thank you.
So we'll do both of them for Barron and Metcalfe on the 14th.
Correct.
Okay.
Yes, sir.
All right.
Thank you. Bobby Johnson.
It's on for sentencing today, Judge.
Yes, sir.
And Judge, also, on one of his cases, obviously he got a new charge when he failed to come back on his furlough. And on 20 CR 76, I had filed a motion to revoke probation on his on that new charge. So I guess after we sentence him, we'd have to set a hearing date on that.
Okay. Mr. Johnson, have you had the opportunity to look at your pre-sentence investigation report?
Yes, Judge.
All right. Is there anything in there that you feel like should be corrected? All right. Are you ready to proceed with your sentencing?
Yes, sir, Judge.
Let's see, Mr. Berry, who's going to be handling this one for you guys?
That's my case, Judge.
Okay.
Or these are my cases.
I don't know if there's been any conversation among you all. So I guess what I need to do is find out what the Commonwealth's position is going to be on the recommendations in the plea in these two cases, without respect to the 20 CR 76, which they have a motion to revoke probation. And you know, it doesn't sound like there's been any resolution of that, so I'll set that for a hearing after we get done here. But, you know, this is one that there was a plea, and as Mr. Richardson alluded to, there was some non-compliance with the conditions between the entry of the plea and the sentencing date. So I don't know, Mike, what your what your position is going to be.
Well,
But before I ask Mr. Berry to make an argument, I guess I need to know what he needs to know what your argument's going to be.
well, I talked to Mr. Berry about a week or two ago, and basically I was like, with what he's facing now, if they just go along with sentencing, we just go ahead and get it done, then, I mean, his cases are already running consecutive for a total of 8, and I would still go along with that.
I see. All right.
Yeah, we wouldn't object to that, Judge.
All right, Mr. Berry. So in 20 CR 130, that was a 5-year recommendation. 20 CR 339 was a 3-year recommendation. In the recommendation, the Commonwealth was opposing probation and shock probation anyway, and consecutive sentencing. So since it seems like that's still okay with everybody, we'll just go ahead and do that, waive fines and court costs. Hold on, Mr.
Okay.
So on the revocation, Greg, do you have a problem if I just set this probation revocation at the same time that we just did Mr. Harris's,
No, that's fine with me.
which is Friday, May the
May the 14th.
14th? At 9 in the AM.
Okay.
So that's this one. Jen, that'll be a whole different ballgame from the rest of them. All right, thank you. All right, thank you.
Thank you.
Correct. All right, Amber Mesker.
Judge, this was one where she was sentenced and you were going to allow her to report to the jail on a later date, and she failed to do so. It was after sentencing, so I don't know if there's much, that I can argue or file any motions on. I think the only thing left to do is just go ahead and get her to serve her time.
Yeah, I don't disagree with you. And yeah, I mean, in fact, we already had the sentencing, so there's not any, I mean, I'm not going to take any additional actions. She's just going to start serving her sentence. Because she was already sentenced, just failed to report to jail. Start serving that sentence today. All right, that's all there is to that one. Rachel Myers Jackson.
Judge, Mr. Berry and I talked about her case. You were holding her for a week because she had been out for a while. If we could put this on at 1 o'clock, Mr. Berry and I he had proposed a counter. I told him that I could probably get him an answer today. So if we could put her on at 1, we might have a deal by then.
That's fine with me. Can you live with that, Mr. Berry?
Yes, Judge.
All right, so we'll just do what? Yeah. Well, Bonnie,
The judge.
we would like to just put Miss Myers Jackson on the 1 o'clock, okay?
That'd be fine.
Or, whenever however close after 1 o'clock we get to it. Okay, thank you. Mona Lisa Pacina. Yeah, I just didn't know if you all happened to have her. That's a Metcalfe County case, so we can't do anything with her, but she's on my list.
Did you want to see her? Because we had her in here not.
I want to see her tomorrow morning, okay?
Okay.
All right. David Pons.
Judge, that's my motion that I filed up. We just need a hearing date.
Your Honor, I guess we need to have a discussion about that. This is the motion that Greg has filed, like he said, about, I guess, a self-defense immunity.
Right.
And obviously, the Commonwealth requests time to file a response to that motion, and also request time to file a notice and submit information to the record so the court can consider that. It's my understanding that in these motions, the court just considers what's of record and then makes a determination based upon that.
Yeah, historically, and we've done several of these, and this law was in effect when I was in district court, and it came up several times down there. And there have been some case law developments over the years, but they have not really changed materially what I'm going to say right now. Historically, the way that I have handled these is because the salient point is whether or not at the time of the arrest, the officers effecting the arrest had probable cause to believe that the immunity provision was invocable, for lack of a better way to put it. To me, and the case law is pretty clear on this, that you do not have an evidentiary hearing and take testimony or have any new evidence presented, but you present what information was available of record as of the time of the arrest, because that's the important consideration for the court, is what the officers knew about at the time. So that being said, what I have historically done is allowed the Commonwealth to provide the information that has been provided to the defendant as far as the discovery information that was available, at the time of the indictment or whatever the case may be. And, we've forged ahead with that. What I would be willing to do is, if you all wanted, just since we put a few things on that May the 14th, if you all wanted me to put this on that morning of May the 14th, and after I do those other hearings, we can discuss whatever we need to. And in the meantime, the Commonwealth can provide me and copy the defense on what you are providing me, and then file whatever you want to file, either a position paper or whatever the case may be. And then if Mr. Berry wants to argue about, whether there's anything else we can do at that time, we can do that. Does that make sense?
Yeah, I think it does, Judge. So between now and May 14th, the Commonwealth would provide the court with what evidence they say was available at the time of the arrest. And what else?
Yeah, well, and I want them to copy you on that, because I want you to know what they're asking me to look at. And I think they're gonna, Mr. Gardner wanted time to file a memorandum, so I think he could file that in that meantime as well. It would give him, 2.5 weeks or whatever. So that's about what we would normally do. And then, we'll get there and we'll talk about whether the matter is ready for me to decide it, or if you think that you can take the position that I need to do something else. We've been through this pretty thoroughly in other cases. I don't know that you've been involved in any of them, but we've had one recently here and one in Metcalf, where I did a pretty thorough order about what I thought the law says, and at least after I got done, I don't think anybody disagreed. But that, I would want to do the same thing and let you look at it and see if you disagree with what I was saying. I'm not talking about the ultimate answer, because the ultimate answer I can't decide until I look at what information is available. But I mean the answer about whether we have any sort of other proceeding other than me reviewing the information of record at the time of the arrest, which is what I think I'm limited to.
Okay.
Your Honor, just to speak briefly on that, as far as the time of the arrest, this case was obviously presented to the grand jury. The grand jury returned an indictment as well. The defense immunity, I think would, apply up until then. So I think I would be entitled to, provide all information the officer had up until, seeking an indictment in this case.
Well, I was just kind of using shorthand. I don't know that I disagree with you, because that's the actual charging decision, charging instrument, if you will, in a felony case is the indictment. So I don't know that I disagree with what you're saying. All right, so let's throw that down for May the 14th at 9 o'clock. And I'm going to say that prior to that date, the Commonwealth can file a memorandum or whatever you want to call it, and provide the information that you believe is relevant for me to consider. And then I will, Mr. Berry can see whatever it is that you're providing to me, and he can argue if he wants to that there's anything else that I need to consider. Okay.
Okay, Judge.
And I may agree with him and I may not. All right, May 14th, 9 o'clock. Savannah Scott.
Judge, that's also mine.
Yes, sir.
I had the same problem with her PSI. I did get it up there this morning, but I don't know if she's had a chance really to look over it.
Okay. Ms. Scott, did you get the chance to look at this pre-sentence investigation report here?
Yes.
All right. Are you ready to go forward with your sentencing, or do you feel like you need to have more time for some reason?
Or we go forward with it.
I'm sorry?
We can go ahead with it.
All right. Mr. Berry, what, if anything, are you wanting to argue on her behalf?
Nothing, Judge. We're just wanting to encourage the court to follow the plea agreement in this matter.
Okay. Well, the big kicker here was that she had a 1-year sentence that was pretrial diverted. Pretrial diversion was voided by order entered on or about March 24th, 2021. I was thinking that at the time that we did that, there may have been some discussion, or at least some desire to look and see what kind of credit she was going to have, custody credit and all that, because it's a 1-year sentence. And, she's been in custody now for, according to her PSI, 121 days on the 1-year sentence. So, the recommendation, such as it is, was that she get a 1-year sentence pretrial diverted, which that ship has sailed. So I guess the Commonwealth's recommendation now is for her to serve that 1-year sentence, which she's already done 121 days of. Is that right?
That's correct, Judge.
And I mean, it goes without saying, I guess, but the 121 days is probably enough to be meaning that in the very near future, she'll be getting released but it'll be up to the Department of Corrections to do that. All right. So, and I would say that I believe this is a sentence or a case where it would be appropriate to do that. I think that, there's just been there was a lot of effort on the part of pretty much everybody but Ms. Scott to make a drug court work, but it didn't work. And so I think it's time to just go ahead and face up to the 1-year sentence. So I will enter an order that I do not believe it would be appropriate to probate it under the circumstances. So I will enter an order and a judgment sentencing her to serve that 1-year sentence subject to whatever credit that she is going to get, which according to the PSI is 121 days. Fines and costs will be, we'll say they'll be served out because of her time in custody. All right. Thank you. Dylan Wyatt.
Judge, that's mine. I had filed a motion to revoke probation. We just need to set a hearing date.
Okay.
Your Honor, could I say something?
Yes.
I do have a bed date for a 6-month treatment program held for me on Wednesday, if you would be willing to do that. I paid all my restitution. I did make a mistake, but I mean, I've lost my job and I've lost quite a bit over that little mistake. Just like to apologize to the court.
Let's see what I did get and I don't know that the Commonwealth got this. I did get I guess it was a fax. I don't think it was an email, but a fax from the treatment facility. I think it was the one you had already been in for a while, wasn't it?
Yes, sir. I completed it once before. I did.
Yeah. Yeah. So, I mean, I don't know if the Commonwealth has, how they feel about that or what they want to try to do. I'd be willing to, Mike, if it would help to maybe put this over to tomorrow and let you see that.
That's fine, Judge. I probably would be willing to go along with it, but I want to take a look at it first.
Yeah. And because I think I do not remember independently when it said he had a bed date, but I mean, if he tells me that he has a bed date for Wednesday, I'm not going to argue with him. And then
Yes,
that way we'll at least get to look at it before then.
Okay.
All right. Can we send a copy? This must have been emailed to me because it wasn't faxed, but I don't know if I still got the email, but we can send a copy of this to Mr. Richardson. can't we? Yeah, I got it on Thursday. Oh, and for what it's worth, this says that your bed date is May the 11th.
I don't know. They told me and my fiance the 28th. So I'm not sure.
Yeah. This says after reviewing Mr. Wyatt's application, the treatment team has decided that if the courts will allow, Mr. Wyatt can come, we can accept him on 5/11/21 at 10 a.m. So, but I'm gonna send this, I'll have a copy of this sent to you, Mr. Richardson. We'll pop this over to tomorrow and we'll, see if we can talk about it then, okay?
Okay.
All right.
Sounds good.
It's only gonna have one case number on it, but it's this, I got the same letter and I printed it twice apparently and put it in both files, but there isn't any reason to send you 2 letters.
Right.
All right. Thank you.
Judge, I've got Mr. Bell waiting on Stephen Ginter. He was wanting to do that, which that's fine, but I don't see Marshall County on here.
Well, let me check with Bonnie. Bonnie, does that have you all covered?
Yeah, Judge, that's all I've got
All right. See you this afternoon, okay?
this afternoon. Let's go out there.
Give me just a second and let me check on that Mr. Ginter thing to see if KP's heard anything. All right, I think we're gonna get, the guy that we deal with over there is apparently not there today. I don't know if he's sick or off or what, but she's talking to somebody else and they said if we sent the link, he'd try to get Mr. Ginner on there. So if we can wait just a minute. I know, Johnny, you've been here with us for a while, but if you can hang in there for a minute. All right, while we're waiting, let's talk to Mr. Pruitt.
Good morning, Your Honor.
Good morning. Is this what we on for final sentencing?
Yes, sir.
All right. Miles, have you looked at your, oh, wait a minute. I don't see his attorney on here.
No, I haven't seen her either.
It was top heavy. I'm guessing that means I can't sentence Miles without his attorney.
They're actually a quality insurance company, saving people money for nearly 60 years.
Do we just want to pass it a week, Judge?
Well, I want to pass it to a time that his attorney will be here. So
Well, if he wants to, I was just gonna write her an email. If he wants to hang on for a little bit, I'll see if she can get on. And if not, see when she's available next.
Can you wait a minute, Miles?
Yes, sir.
I mean, she was here when we set this one.
May I?
All right. See what you can find, please.
Sorry about that, Judge.
I'm not really going to blame you for it, Miles. All right, let's see what else I got. Who else do I have? I've got what? Alex, of course. What's that about?
Yes, sir.
Yeah. Hold on a second there. Let me get your information. All right.
Judge, after Mr. Sikorsky is arraigned, there was an issue I wanted to address on bond after that.
All right. Mr. Sikorsky, right?
Yes, sir.
Can you tell me your address and your date of birth?
118 Lexington Drive, Glasgow, Kentucky, and June 1st, 2000.
Okay. Did you say 118?
Yes, sir. 118 Lexington Drive.
Gotcha. Thank you. All right, Mr. Sikorsky, do you have an attorney representing you?
No, sir. The county clerk said you would appoint me one.
All right. Let's see. Okay, Mr. Barry, I'll need to appoint someone out of out of your office to represent Mr. Sikorsky. I'm not sure he ever actually got served because I think his address changed somewhere in the midst of, with us not being in court. We've got several letters that came back that were sent to a West Front Street address. So,
Okay, Judge.
Yeah.
Ms. Myers will be representing him on this case.
All right, very good. So, Ms. Myers, do you wish to have a formal arraignment or do you wish to waive those formalities and proceed?
We'll waive formal reading of the indictment, Your Honor, and enter a plea of not guilty, reserving all pretrial and pre-arraignment motions as if presently made.
Gotcha. Yes, ma'am. So, Mr. Sikorsky, this is what I'm going to do. I'm going to go ahead and put in on your behalf a plea of not guilty. Before we wrap up here, I will have you and your attorney talk about ways that you can contact her or she can contact you, whatever you all decide to do. I'm going to set your case for a pretrial conference, and I was wanting to do June sometime, Ms. Myers, but I can't remember. Can't remember if there was a time in there, if it was June or July that you had a day or two you weren't going to be available. So you tell me.
Sometime in June would work. Okay, I think, Your Honor.
All right, so let's put him down then for June the 14th at 1 o'clock.
Hey, Judge, June the 14th, I'm going to be on vacation.
Okay.
I was going to suggest if we can do it June 21st.
Okay, no problem. June 21st. All right. So, Mr. Richardson, what you had mentioned that you wanted to bring up something.
Well, he may have already answered the question, Judge. So did he not get, I was kind of wanting to know when he got served, because when I was going over his record, he's got 2 new charges. One is a no insurance. I'm not really that concerned about that. The one I'm concerned about is he's got a new DUI and driving without a license and negligent in an accident out of Owensboro. And he received that on February the 27th. So I was kind of wanting to know if he was actually served or not. If he was, I'd file a motion, but if not, I guess I can't.
Yeah, that is a good point. And he has not ever been served with this because they, again, I think he had a different address when he saw the district judge than he has now. And so that was what was on his indictment and his summons. And there's several that come back in here where the process server has returned them as unable to serve or whatever the case may be. And then we've got a bunch of letters, with the court dates on them that have also come back undeliverable. So this is how we need to handle that. Because, he's submitting, I guess the way to put it, submitting to the authority here by appearing when he hadn't been served. I am going to just state for the record that rather than to go to the trouble of either issuing an arrest warrant or another summons and serving him, I'm just going to point out to him that he is under, based upon his bond, under an obligation to, basically to avoid violations of the law and illegal substances or intoxicating substances. He needs to make sure that he stays in contact with his attorney and makes all of his court dates. And specifically, but not limited to, the June 21st, 2021 court date that we just scheduled. Ms. Myers, do you all need to talk about any kind of number exchange or anything?
I can give him my number. I've also sent him a direct message through the Zoom link asking him to text me or to message me his telephone number. But our office number is 1-833-385-6055. But if he would still go ahead and respond in that chat box with his number.
I will do that.
Yeah, Mr. Sikorsky, just we're done, but stay on this hearing until you and Ms. Myers have chatted back and forth and gotten that worked out, okay?
Your Honor, I do have a question.
Yeah.
The black car that I had that was in my possession at the time, I did have some tools, and I do have receipts.
I think maybe your attorney doesn't want you to talk about anything about your pending charges here in public. You need to talk with her, and then, you all see what's the best way to present whatever you want to present to me, okay?
Yes, sir.
Yeah, I mean, you just need to not say anything. Everything we're saying is recorded, so you need to just not say anything till you've talked to her, okay?
Yes, sir.
All right, thank you. All right, Mr. Pruitt, I believe your attorney has joined us, so let's go ahead and get back to you. Are you still with me?
Yes, sir.
Good morning, Judge. I apologize for my delay. For some reason, my link was not working that I had used previously. It might have been my computer, though.
Okay.
Ms. Risa was able to send me over a link that did work. So I'm
Gotcha.
here now and able to hear you.
Mr. Pruitt had indicated that he has read his pre-sentence investigation report. I don't think I got to the point of asking him if he wanted to make any sort of changes or anything like that. Ms. Myers, that chat's going to everybody. Not yours, but his. So FYI, in case anything, nothing so far that I didn't already know, but FYI. So Mr. Pruitt,
Yes, sir.
you have read the pre-sentence investigation report,
Yes, sir.
and did you have anything in there that you believe was incorrect or that you needed to discuss with me about modifying?
No, sir.
Okay. Are you ready to proceed with sentencing, or do you feel like you need to talk to your attorney before we do that?
Yes, sir. I'm ready to proceed.
Okay.
I may, for the record, I did not receive a PSI.
Oh, okay.
I had contacted probation and parole a few weeks ago to ensure that Mr. Pruitt did appear and was interviewed by them, and they had not completed the report at that time. I gave them my email address, but it did not come to me eventually. But if Mr. Pruitt has indicated that he is ready and that he is satisfied with its contents, that it is true and accurate, then I have no reason to delay the sentencing.
Yeah, I would think that in a case like this, the big bone of contention, if any, would likely be the credit, because he did do some, he did do a little bit of time in custody.
Yes.
Miles, it's got you down as 97 days of credit. You're not arguing about that. I mean, I'm not saying that you should be arguing about it, but are you agreeing that that's the amount of pre-sentence credit you should be entitled to?
Yes, sir.
All right. All right.
Your Honor, may I be heard briefly on this?
Yes, you may.
It's my understanding he was still being monitored by U-Turn pending sentencing, and he did have a dirty drug screen. He was positive for marijuana. I contacted Ms. Atkins last week, and he did have a clean drug screen, but obviously it causes the Commonwealth concern with his ability to follow the conditions of probation. That combined with, the motions that we've had to revoke his bond because there's been drug use and other issues. I'm not saying that I'm not going along with my recommendation at this time. However, I feel like the social service clinician assessment is something that needs to be done immediately. And I just want to put Mr. Pruitt on notice that if there is another violation, another dirty screen, or something similar, I probably will be asking to resolve that hearing with sanction, but rather with revocation.
Yeah, I understand. And let me tell you.
Can I speak?
Well, probably not after I say what I'm going to say, because, sometimes when you're ahead, it's best just to not talk. But you had just gotten out of jail. I mean, you had just entered your plea, and the dirty drug test was just like a day or two after we had been in court doing your plea. And, it was marijuana, and I thought there was a chance that it, was residual from something which you shouldn't have been doing then either, but it was not something that I felt strongly about doing anything about at that point in time. But certainly, after that, if it happens in the future, it's going to be really hard to make that argument.
Well, and I think he'd been in jail for maybe at least a week prior to when we resolved it. So I don't know how residual that would be. In my opinion, I'm not an expert on that, but
yeah, it's highly possible that well, we don't need to go into that, but I mean, I know the situation, and I was aware of that test, and there isn't any way to know for sure, but I was giving Miles the benefit of the doubt that it might have been something that was in his system prior to his entry of that plea. And whether it was or it wasn't is immaterial, because I didn't do anything about it. So we're just going to move forward with the understanding that I won't be able to make that assumption if you have a dirty drug test at this stage. Okay.
Yes, sir.
All right. Mr. Pruitt, I'm going to go ahead based upon your agreement with the Commonwealth and sentence you in accordance with the recommendation of the Commonwealth, which was a sentence of 5 years to be probated under supervision of probation and parole for a period of 5 years. As Ms. Gardner pointed out, there is a substance abuse assessment component to that. So the probation officers will talk with you about getting that scheduled.
Yes, sir.
They're not going to ask you to schedule it. They'll take care of the scheduling. You just have to go where and when they tell you to go. Okay.
Yes, sir.
All right. If they recommend as a result of that assessment that you do any sort of treatment or outpatient, or IOP or, NA or AA, whatever they recommend, that's part of your probation that you would do. Okay.
Yes, sir.
All right. Other than that, your probation terms will be as you would probably expect, which are, which will be things like report when they tell you to report. Don't get in any trouble. Don't break the law. Let them know where you're living. Don't move without their approval. Report contact with law enforcement within 72 hours. No drugs and alcohol. You know the drill, right?
Yes, sir.
All right. Because of your circumstances and having counsel appointed to represent you, I will waive your fine and your court cost. Because I want you to be able to dedicate yourself to getting whatever issues you might have going on under control. And I know that part of what we've talked about in previous hearings has been, there's been some history of marijuana use. I just want you to know that I understand there is a generational divide in all likelihood between how people look at marijuana use when they're a certain age and how the court system and the law enforcement looks at marijuana use. But you need to understand that as we sit here today, it is not legal to consume marijuana. So, it won't be a no big deal thing if you get marijuana tests while you're on probation. Okay.
All right.
I mean, alcohol is legal. And if you test positive for alcohol while you're on probation, it is not a no big deal situation either. So, you just need to refrain from intoxicating substances that have not been prescribed by a medical professional. Okay.
Yes, sir.
Officer Bray is on here. He is going to tell you, he's a probation officer. He's going to tell you where and when he wants you to report. Officer Bray.
Yes, sir. Mr. Pruitt, come on in today.
Yes, sir.
2:00.
Yes, sir. I'll be there.
All right. You know where you're going, Miles?
Yes, sir. Reynolds Road.
Yes, sir. You got it.
Yes, sir.
All right. Do you have any questions?
No, sir.
All right. Listen, let's take care of this. Okay.
Yes, sir.
All right. All right. Let's see. Miss Faith, do you have anything?
No, sir. And again, I apologize for my delay.
Okay. All right. Have a good day. No problem. Have a good day.
Thank you. Bye-bye.
Be good, Miles.
I will. You too, sir.
All right. Let's see. All right. I have a honestly can't tell who this is. It's U318AA. Docket here. I'm just going to go down through here and read off some names. Dennis Bunch. Is that you? Yeah, you're on mute right now. Let's get that taken care of. There we go.
Unmute.
Yep.
Can you hear me now?
I sure can.
All right.
All right.
All right.
So you're Dennis Bunch.
Yes, sir.
Mr. Bunch, can you tell me your address?
9098 Edmonton Road, Glasgow, Kentucky.
9098 Edmonton Road. Okay. Huh? That's what you have? Where'd you get that? Oh, okay. All right. Can you tell me your date of birth?
9/22/64.
Very good. All right. Mr. Bunch, you are here because you were indicted by a grand jury in Barron County on the offenses of burglary in the first degree and strangulation in the first degree, both of which are the subject of an indictment that was issued at this stage. It's been a while. Let's see. September 24th, 2020. Do you have an attorney?
No, sir, I do not.
All right. Do you need to talk with me about whether one can be appointed to represent you?
Oh, yes, sir, I sure do.
Okay.
Yeah, I need to have one appointed for sure.
All right. All right. Mr. Berry, I believe we can do that. He did have counsel appointed at the district court level, so there's already been a qualification there.
I'll represent him on this one, Judge.
All right. And Mr. Berry, the other thing I guess we ought to talk about, I am not entirely sure that he's a little bit like that last case that we talked about a minute ago. I'm not entirely sure that he's ever gotten served with the actual summons. So I just want to point out that rather than go through all those gymnastics, if you all will agree, to a waiver of that, then I'll point out to him that he's out on bond, and I'm happy to leave him out on the same bond conditions unless we have any problems going forward. And we hadn't had any up to now. So I think.
No, we had no problem waiving that, Judge. And
all right. And just so that the record is clear, he is on a bond. He was on a bond, and I'm imposing the same conditions: not to violate the law, not to have contact or communication with the alleged victim in the case, not to use illegal substances, have new arrests. And I'm going to add that he maintain contact with his attorney, which is going to be Mr. Berry, and that he makes all of his court appearances that are scheduled and of which he has notice. So, Mr. Bunch, you've made this court appearance, and that's good. Mr. Berry, I guess we need to talk about whether or not you all need me to read you the allegations in the indictment and explain his rights, or do you want to waive that?
we'd waive formal arraignment, Judge, enter not guilty plea to all charges.
Okay. Mr. Bunch, I'm going to appoint counsel for you. I'm going to enter a not guilty plea on your behalf. We're going to schedule this for June. Ms. Gardner, will this be your case?
Yes, Judge.
All right. So I guess I better say June the 14th then, because I almost said June 21st, but I think you're going to be gone.
I'm here June the 21st.
When are you going?
June 28th.
Oh, well, I already said the 14th, so we'll just leave.
Okay.
For some
I'm
reason,
here that day too.
Yeah, for some reason, I thought you said you were going to be gone the 21st. All right. So, Mr. Berry, what do you want to tell Mr. Bunch about how you all can get in touch with one another?
Do you have a telephone number, Mr. Bunch?
Yes, sir, I do.
Okay, don't give it to me right now. You know, can you use the chat in your?
Sir, I'll be honest with you. I'm afraid to even touch this thing. I don't know how I got on there with you guys. I don't know how to use it.
Okay, do
You're doing okay so far.
Yeah.
Well, yeah, I got on here, so I'm real happy about that.
You have a pen, you can write down my phone number. I'll give
Yes, sir, I sure do. Yeah.
It's 833-385-6055.
385-6055.
Right.
Okay.
Get in touch with me, okay?
Today? Immediately?
Yeah, no, probably about Wednesday or so.
About Wednesday. But what time of the day is the better for me to contact you?
Try anytime. I can't give you the best time of day. I don't know.
I'll call you at 6 a.m. then.
Yeah, you probably won't be.
All right, so I'll contact you on Wednesday for sure.
Okay. All right, Mr. Bunch, be sure you and your attorney talk before I see you again in June, okay?
Yes, sir.
All right, you're free to go. Thank you.
Thank you.
All right, we've got Marshall County with us now. I do believe.
We are here, Judge.
All right, thank you. Mr. Bell,
Yes, sir, I'm present.
did you already give me that phone? Yeah, you did, didn't you? All right, so where are we?
Judge, Mr. Bell had contacted me this morning and I guess there's a proposal. I guess there's a willingness to try to plea bargain, but they're wanting more of a global deal. So I told Mr. Bell that I would contact the Commonwealth Attorney in Marshall County and see if we can get a plea deal together and get that to them. The next time he goes back to Marshall County is June 22nd. I don't think we have to wait past that. I was going to suggest if it's a good date for Mr. Bell to put this on May 17th, or if that doesn't work for Mr. Bell, we can do another date in May. That'll give me enough time to get with Marshall County. I'm sure it won't take that much to get them to make me an offer, and I can relay that to Mr. Bell.
May 17th is fine with me, Your Honor.
All right. And we'll be, because he's in, jail in Marshall County, we'll be doing that one remotely, okay?
Yes, sir. I thought everything was going to be remotely now until June. I thought the Supreme Court had sent out a letter. Is that not correct, Judge?
That is not correct.
Okay.
We'll discuss it.
Yes, sir, that's
I mean,
fine.
we've got some flexibility, but I mean, something like this, there's no,
Right, yes.
there isn't any reason to do something like this in person anyway, so we're good.
Yes, sir.
What'd you ask me?
May I ask a question?
Wait, hold on a minute. So did you all say 10 o'clock on May 17th?
Yes.
All right.
What was your question, Steve?
Is this going to include Warren County? Bowling Green?
I can call Warren County, Johnny.
Yeah, yeah, because we'd like to get everybody included, Stephen, so we'll know what you're looking at in
That's
the
fine.
totality.
Right.
All right. Mike, get the balls in your court.
Thank you, Judge. Y'all have a good day.
Thank you.
Thank you.
Thank you all over there in Marshall County.
Welcome, Judge. Have a good day.
You too. All right, let's see. Who else do I have on here? Who's 270-303-1898? Don't make me guess. All right, well, let's go through and see who I still need to deal with. All right, Cody, I don't have the files on these, but I'll get them. But I'm just going down through my list. Cody DeVore.
Judge, that's my case. I think it's on for a payment review.
Okay. Yeah, he had been making some payments along the way here. There hadn't been a payment made since February, but his balance is $913, which I think is probably some progress over where he started, but I don't know how much. Not a ton, I guess. Yeah, he started with 1,200 and something 18 months ago, 14, 15, 16 months ago. I mean, it's just There's absolutely no way to navigate this without spending 15 minutes trying to figure out. Well, you should have paid between September 22nd and December 21st. I ordered him to pay $300. And he paid 150 and 50, 200. Hold on. So he didn't pay. No, he paid the 300 prior to December, like I told him to. And then he's owed 50 a month since then. So that's January, February, March, and April. And he's made that, right?
He made one in January, one in February, and 2 in February.
Yeah. So he's probably at worst, since I saw him in September, $50 behind. Yeah, for this month. Does that make sense?
It does.
So I will, I tell you what, let's go over to June the 28th. I don't want to go too far away. June 28th, that's 2 more months. And we'll send him a notice. Is he on, is his diversion supervised as far as you know?
Judge, I think it is, but I can't say for certain.
Yeah, I was hoping you just remember off the top of your heads, but I think it is. Yeah, it is. All right. So what I want to do, Officer Bray, is have somebody reach out to him if you don't care.
Judge, he is on Officer Lauren Wilson's caseload in Bowling Green. I'll go ahead and I'll send her as well as Officer Hogan, who's partially taking care of that caseload. I'll go ahead and cut them an email right now, tell them what's going on.
So I want him to be with us on June the 28th. He will owe $150 by then.
Yes, sir.
All right. Here it is. Oh, here it is. All right, Jennifer Dix. Is that payment?
Yeah, I think that'd probably be a payment review as well.
She paid $250 last 2 weeks ago, 3 weeks ago. Paid $150 in January. I can't really tell again what that. She owes $100 a month. So that's probably not exactly right, but close. She's probably not on supervised probation, is she? Because didn't she end up pleading to a
I think it's a misdemeanor, Judge.
misdemeanor? Oh, well, no, they've got her. We have a report.
Yeah.
From probation and parole in June of last year. So I guess let's do the same thing on her. Wes, the last thing we got from probation and parole was Officer Bragg.
Okay. How far is she behind?
$100 a month, and since September, it looks like she's paid $500.
She's
so
quite a bit behind then.
No, That's wrong. Since June of last year. So July, August, September, October, November.
About 700.
March. Looks like she probably should have paid 900 by then, and she's paid 500. So she's about 400 behind.
Okay. June the 28th on her as well.
Yes.
That's in person on both of those, right?
Yes.
Okay. Thank you, sir.
June 28th. Chris Gentry. Pretrial diversion review.
Judge, I'm not seeing anything, so it can be dismissed.
All right, thank you. Ralph Logan.
Judge, that's mine. I have a note here that he's in Pike County. I think that's where he was the last time.
In jail in Pike County?
Yes, sir.
Oh.
I believe that's correct, Judge.
I guess that just flew, yeah, in February, we set it to today, and I guess that just flew over. We didn't send them anything, did we? Oh, she did set it up. Uh-huh. Well. Fine, how do you do? Yeah, all right, so I misspoke. We did send them a link, but here we are holding the metaphorical bag.
Well, Judge, I mean, there's not a whole lot we can do today. I think the last time we talked, we were supposed to talk again about a counter, but it's been so long. I don't remember, Greg, if you ever sent me a counter or not.
I'm not looking at his file right now, so I can't remember.
Yeah, I mean, we'll just have to, we're gonna have to continue it anyway.
Let's put it on June the 7th and see what happens.
Okay, Judge.
So were we thinking he was a state inmate?
Yes, that was I think isn't that right, Greg? He was
Yes.
Yeah.
All right. Fred Kent Parker. That's another payment review, I bet.
It is, Judge. I believe that he's behind as well. We've gotten calls from the victim in this case saying that, she hadn't received anything in a substantial period of time.
You are correct. He has not made any payments since the last time that we were in court, which was 6 months ago. All right, so I'm doing a bench warrant on that. All right, we'll do a bench warrant. Oh. Preston Pritt.
Your Honor, I believe that was on to see if he had provided proof to the court that he had enrolled in a substance abuse program.
I got nothing.
Okay. I guess I would ask for a bench warrant then.
We can sure try. He was living in Memphis, Tennessee, so.
Yeah, I understand.
Stephen Smith. That's the one that's supposed to be on, oh, well, there's Josh Spears. That, it was supposed to be on for sentencing.
Judge, I've tried to contact him. I've used every number I have, including one I found on his pretrial report this morning. And the woman who picked up had never heard of him, said I had the wrong number, so. And I'm pretty sure he's never contacted me in any of the times recently, so I have no clue where he's at.
Well, I'm gonna have to issue a bench warrant just because we have to bring this case to some sort of resolution, and that's apparently the only way to get him in here.
Mm-hmm.
So, let's do a bench warrant, $500 cash bonus. Cody Stinnett, Jody Tucker, Anthony Wheat. That's everybody.
Judge, I had Rebecca Brown on.
Yeah, hold on. I'm trying to see what Anthony Wheat's on for.
Judge, that was on for a motion to forfeit, and I think
Oh.
you've already signed the order on that.
Yeah, yeah. No action required. Rebecca Brown.
Is that her, the telephone number, the 191898?
Your guess is as good as mine. I mean, I'm not trying to be a smarty pants. I don't know, because I called out that number about 15 minutes ago and nobody ever, I asked them to unmute and get on, and nobody ever, unmuted.
I'm thinking that might be her.
What?
But I don't know 100%.
Oh, that's not the number that she used the last time, because Crystal wrote it down and it was something different. 9724 599-9724. But I mean, I don't know what to do with her.
We were on to see if I had made an offer in lieu of, I think, voiding her diversion, if she would get a Kentucky recovery.
I think she's agreeing to that. I was kind of under the impression that she was getting online today because I've been in contact with her, but I obviously don't see her on here, so.
Well, how would you all like to proceed?
Xanda, do you think you could get in touch with her and maybe see if she could appear tomorrow afternoon, if that would be okay, Judge?
I might be able to get her on this afternoon if
That's
the court's
fine.
okay with that. She's been in frequent contact with me, so that's why I was kind of a little surprised that I wasn't seeing her on.
Yeah, I mean, I'm okay with either one. I mean, if you have been talking to her, I take your word for it. And so if you want to get her on today, or if she shows up today, that's fine. If she doesn't show up today, or if she shows up tomorrow, that's also fine.
All right, thank you.
All right. The only other thing I've got, how on earth, how is that even possible? Cool. Good Lord. Somebody punch those holes that can't see. I got one more person that's late to the party here. Literally.
Hello? Hello?
Yeah, who do I have?
This is Rebecca. I called off a 303 number, but apparently I was muted and it wouldn't come unmuted.
Oh, okay. Well, so this is Miss Brown, right?
Yes, yes.
All right. What do y'all want to do?
I believe she's accepting the offer of going to treatment. Isn't that correct, Ms. Brown?
Yes.
Okay.
I just don't know where I'm going or how long I'll be there.
Yeah, that's a very good question.
Andy was going to arrange that, Judge.
She'll also need transportation to there. That's been one of her biggest problems, I think, is having transportation.
As of right now, I do have a ride, but it won't be until the 1st.
Yeah, well, that's
I think
probably, yeah, it's
I
probably.
think it's
okay.
one of those things we don't know when or where she's going until Candy puts her on a list. I have talked about transportation issues with her. Something, I think she might be able to arrange something, but I can't promise that.
So, is she going to go to treatment and then do
Drug court, yes.
drug court afterwards?
Yes.
Yeah, okay. All right. So do we need to give, I think I just need to give Miss Brown Candy's number and vice versa so that, you know, when the bed date becomes available, they can communicate. We just have to make sure that we don't fall into the same hole of not responding or communicating with the drug court people.
I would just maybe ask if we could put this on May the 10th for a review, just to see where we're at, if she's in treatment by that time. We don't have to do anything, but I'm texting with Candy right now, letting her know that she's accepted the resolution for her to go to treatment.
I don't have an objection to putting it on to review, but there's not.
Oh, that's right, you're gone.
I'll be in trial.
I forgot about that.
Candy also said that if we give her any court dates in the next 6 months, she can't get her in anywhere.
Oh, okay. Well, then don't worry about that. I guess maybe if we can keep an eye on it without doing a formal court date.
Because that's what always happens in these, you know, they'll have district court dates or whatever, and we have to get the district judge to move their court dates out past 6 months and all that, or ask him to do that. So, all right. So Miss Brown,
Yeah.
Do you have Candy's number?
It's 1111 the last 4 of it, right?
Yes.
Okay, then yes.
You need to give her a call today after, or you know, like this afternoon after 1 o'clock, okay?
Okay, I will.
All right. All right, folks. Anything else y'all want to talk about?
Yeah, Judge, if I could talk to you and Xanda about an issue.
Yes.
Nobody else has to stay